We were honoured to have the Honourable Michael Kirby provide a welcome address for our seminar. As you will see, Mr. Kirby reflects upon his own personal experience with the law, in particular as a member of the judiciary, sitting in some of Australia's most well-known miscarriage of justice cases. Mr. Kirby provides an inspiring call for us to commit to delivering justice in our criminal justice systems in Australia.
I'm Michael Kirby on the occasion of this important seminar organised by the International Commission of Jurists, Queensland chapter, the Innocence Project and Law Futures, and I'm pay my respects to all of those. The experience of growing up as someone who was LGBT taught me the injustices that can occur in our criminal justice system, despite all the efforts of the law and of legal practitioners and of the judges to avoid that. And if I needed a reminder of that, I got it in the High Court of Australia, because soon after I joined the court in 1996, I sat with Justice Toohey and Justice McHugh in the Mallard application for leave, special leave to appeal. Mr. Mallard on that occasion got a dream court. Justice Toohey, Justice McHugh and I were people who were judges who were not unsympathetic to the obligations of the prosecution to prove matters beyond reasonable doubt and to injustices that can occur in the trial. But Mr. Mallard's application for special leave to appeal was resting on an argument that he had been denied a request for the subjection of him to a truth test, and that because he hadn't had that benefit, he said he had been the subject of a miscarriage. And unfortunately, that was not an argument that was very persuasive, and so his application was rejected. Mr. Mallard, on his second application, had an excellent team of lawyers. Malcolm McCusker, later Governor of Western Australia for a short time, but still concerned about issues of justice, and Jamie Edelman, then quite a young barrister, and they put together a very different case. Their case showed the injustice that had arisen from the fact that the objective time when Mr. Mallard was discharged from the watch house and in Perth, and the objective time when he did a runner from a taxi were just not consistent with his being moving from that part of Western Australia, you have Perth, which had the watch house, to the place where he fled the taxi. And it was by a careful examination of the facts, which had not been undertaken either by counsel or by the court on the first occasion, that Mr. Mallard was able to establish not only that he was not proved guilty, but that he was probably, in fact, innocent. So this was a true example of an innocence project which unfolded in the course of the argument on the second application for special leave to appeal. That reinforced my own native suspicion that not all trials are perfect and that we have to do better. Now, the English legal system, which we copied and which has many very fine features, was resting largely on the principle that juries would not, with a requirement of unanimity of 12 jurors, as it originally was, would not convict innocent people. and normally that is the case. But unfortunately, in a small number of cases, a persistent number, that doesn't happen. And this was realized in the 19th century by the establishment of the Crown Cases Appeal form of appeal, whereby a point of law was reserved, and then that could be argued as an appeal. But that wasn't very satisfactory, so that was replaced in England by the Criminal Appeal Act of 1907, and that provided for various grounds of appeal, including that approved miscarriage of justice was established. And that became the template for similar legislation throughout the then British Empire, including throughout Australia and its colonies and later its states. And that became the basis on which cases more recently have been dealt with. But unfortunately, the problem of miscarriages of justice didn't go away. There was a threshold question that arose in the High Court soon after my arrival there in a case called Postiglione and the Queen. And in that case, the question arose as to whether once an application for a leave to appeal or an appeal was taken to a court of criminal appeal, you could have a second go at it. Would it be possible to have a second application for leave to appeal or appeal? And in my opinion, expressed at the time, there was nothing in the statute and there was nothing in the inherent nature of the purpose of the statute that prevented it. And accordingly, I did not agree that there was no opportunity for a second appeal, but that was not a majority view, and accordingly, to change that, it became necessary for there to be legislation. Professor Bob Moles and his team in South Australia moved to get legislation enacted in South Australia. The government at the time was opposed to it, but independents in the upper house, the Legislative Council, agreed with his submission, and accordingly this was placed before the Legislature of South Australia, and ultimately it provided in cases of clear evidence and argument that a second appeal might, by leave, be granted by the courts of criminal appeal. That innovation was copied soon after in Tasmania, and thereafter in Victoria, and thereafter ultimately in Western Australia. And Malcolm McCusker hasn't told me whether he had the responsibility as governor to sign the law into being. Perhaps he'll share that with you. But one by one, the states of Australia provided for the second appeal. But some states held out, Queensland and New South Wales. But I think now we're down to only New South Wales holding out, and that is a great tragedy. What is so wonderful about New South Wales, and I think the Northern Territory, that they don't have this benefit of a second appeal. But a second appeal, as evidence has demonstrated, is not going to be a perfect answer to the problem either. And that being the case, one looks around the world at countries with a similar legal tradition to our own to see how the issue of miscarriages of justice is handled in those countries. In the United Kingdom, by reason of the so-called Irish cases in the 1980s and 1990s, where many injustices were later demonstrated to have occurred, and in Scotland, in England and Wales, and in Northern Ireland, eventually there was a conviction that something better than the Court of Criminal Appeal even with a second ground of appeal, was required. And that led to the establishment in England of the Criminal Cases Review Commission. And all of you present at this conference will know this history. It's a long history, but our criminal justice system is a long established system with various protections built into it, but sadly not sufficient. And in New Zealand, the proposal for a Criminal Cases Review Commission was followed. That led later to Canada, where a Criminal Cases Review Commission has been followed. But although the Australian Law Reform Commission recommended such a development for Australia, it has never been implemented. Not a single state of Australia has yet implemented this proposal. Now, why do we need it? I think I can throw some light on this by my experience as a judge in the Supreme Court of New South Wales, sitting in the Court of Criminal Appeal, participating in criminal appeals. Most of my work was in civil appeals, and that was a very heavy and burdensome job as President of the Court of Appeal of New South Wales. But on Fridays, I would generally sit in the Court of Criminal Appeal, and the docket, as the Americans call it, included generally 2 substantive appeals against conviction, and often 1, 2, 3, or sometimes 5 sentencing appeals. This is an enormous load on judges. It was shared out by the presiding judge, and that meant me. I was supposed to take a good part of the burden, and I did. At the least, the work in the Court of Criminal Appeal was a very heavy load, even for conscientious judges, and I would count myself as very conscientious, and most of my colleagues as very conscientious. People had their different views about the importance of finality and the importance of the competing ideas of justice without any reasonable doubt. And this led to sometimes having differences of opinion, but always to tremendous pressure on the judges to get through their list. So in that pressure lie the seeds of mistakes, of oversights, and as in Mallard, the inability to examine at length with a fresh mind and in different ways than counsel had propounded whether or not the prosecution had proved the guilt of the accused. And it was for that reason that I thought that in Australia, the notion of establishing a criminal cases review commission was one that should be considered by government, and I think one that should be implemented. It's important to say that it's not an absolute complete solution to the problem. In New Zealand, for example, since the Criminal Case Review Commission was established in that country, very few cases have got the tick to be reconsidered by the Commission. And even in the United Kingdom, partly it seems by the lack of resources in the Commission, the number of cases where leave has been granted and the matter has been referred back for correction to the courts. So the problem of dealing with miscarriage of justice is a problem that should haunt all lawyers, because we are involved in the business of securing justice according to law. But it's also one that is uppermost in the minds of prisoners, particularly if they have been convicted unfairly or wrongly. And I think it's one that should concern the whole of the community. And that's why this seminar at Griffith University in Queensland is so important. We've had so many cases recently where either by reason of a royal commission or a special commission of inquiry or of a second appeal to courts of criminal appeal, injustices have been demonstrated. So it was held by the High Court in the case of Mallard. So it was held by the High Court in the case of Cardinal Pell. So it has been held by later inquiries in the case of Mrs. Folbig. And so even conscientious judges and lawyers can make mistakes. And that is why this seminar is very well timed in Australia to consider our record, to consider what other countries have done, to consider whether we should follow them, whether we should do more or differently in the age of forensic evidence. And I think it's therefore very timely that this seminar is taking place. I congratulate the organisers, and I hope that it will come up with fresh ideas and a fresh incentive to get behind the correction and improvement of our legal system.